this hearing today. This is the joint hearing of the Senate Business Professions and Economic Development Committee and the Assembly Business and Professions Committee. Today is the second day of sunset oversight hearings the committees are conducting this year. These hearings are part of the committee's ongoing responsibility to exercise oversight of state agencies under their jurisdiction. The primary purpose of this review is to assess the effectiveness and efficiency of these agencies in protecting consumers and to determine whether changes in the law or in their operations or functions are necessary. Today, we will be reviewing specific issues regarding the Department of Consumer Affairs, the Board of Registered Nursing, the Board of Vocational Nursing and Psychiatric Technicians, and the Dental Board of California. To assist members in the review and evaluation of each agency, staff has prepared a background paper which identifies issues and makes specific staff recommendations for each agency. This paper has been posted on the Senate Committee's website and made available to all interested parties. Staff has also asked each agency to focus its comments in this hearing on the more critical issues that have been raised. We will ask the department to address the Breeze IT project and its Consumer Protection Enforcement Initiative. And we are asking that each board begin their testimony by providing members with a brief review and overview of their programs, and then respond to the more important issues that are raised by staff. Members will also have an opportunity to raise any other issues or questions which they may have. We will also have the opportunity to hear from consumer groups, professional organizations, and members of the public. I would also like to invite my co-chair, Assemblymember Susan Bonilla of the Assembly Business Professions Committee, to make any opening comments.
I just want to say good morning and welcome to everyone. There's a lot of information here for us to get through today, but it's very, very important, and I just want to thank everyone in advance for their participation in this very important hearing. Thank you.
Thank you very much, Madam Chair. And also like to recognize Assemblymember Bloom, Dodd, and Jones for, Baker. Yes, good morning, Ms. Baker. Thank you, and welcome. Would you care to make any opening comments at all? Very good.
I'll save all my pointed comments for
All right, that sounds good. I'm sure we will all have those comments. Well, let's begin. Our first panel will be discussing the Breeze IT project. So if the first panel would come forward, I'd appreciate it. And Ms. Howell. Oh, there she is. Morning. Oh. And just wanted to mention that Sub 4, Assemblymember Bloom is here. He's the chair of Budget Sub 4 in the Assembly. 3, thank you.
I don't know, maybe not. One must be the...
I don't know if those numbers make any difference in that regard. Well, good morning again, and thank you very much for your participation today. And perhaps what we will do is begin with Ms. Howell, our state auditor, and then we can introduce after that those who are with us and joining us in this panel. So, Ms. Howell, welcome.
Thank you, Mr. Chair and members. For the record, my name is Elaine Howell, California State Auditor, and what I thought I would do today is just do a very high-level overview of key issues that we identified in the audit report that we issued in February, just last month. There were 5 key issues that we identified in assessing the Breeze project, starting with planning, oversight, project delays, escalating costs, and we had some concerns with respect to the contract that the state of California entered into with Accenture. So starting with planning, the key issue we identified here is that Consumer Affairs failed to adequately plan, staff, and manage this project from the very beginning. One of the concerns we identified in this report was related to assessing the business needs of all the various boards and bureaus and commission that this Breeze system was intended to be a resource for all of those regulatory entities. It didn't really identify the business needs. It used business needs that had been identified in previous projects that ultimately had been abandoned. So it would have been better for them to go back and sit down and work with all of the entities to really understand what their business needs were. With respect to, additionally with respect to planning, DCA didn't establish a baseline set of requirements. So they had a baseline set of standards that Accenture was expected to develop the system requirements around. And those requirements really identify how that system should operate. And they didn't really establish that baseline and stick to it. So those were two key concerns with respect to planning. As far as oversight, Caltech got involved in working on this project. They certainly, as Mr. Ramos and others can explain, Caltech has a very important role in California with respect to information technology oversight, planning, et cetera. Independent oversight, both IV&V, which is looking at those system requirements, and IPO, which is your project oversight, looking at how well the project is being managed from a time and cost perspective, didn't really get started until a year after the initial FSR was approved. That type of oversight should be occurring immediately, and they got involved a year in. There were some very good issues that were raised by IV&V and IPO, and that was another concern that we had. Even though these issues were being raised and weren't necessarily being resolved in a timely manner by Accenture or by Consumer Affairs, the project continued. More and more costs were being expended. The timeframes were being extended, which is, you know, time is money. So we had concerns with respect to that. We specifically identify, we have an IT expert who works with us, and we have an appendix in the audit report that identifies 180 significant issues that were persistent, that were occurring or were showing up in monthly reports month after month after month and not being resolved. And these issues revolved around project management, staffing, the system requirements, and the performance of the vendor. Even with all those significant concerns, the project continued. And as we discussed in the audit report, there were, you know, additional special project reports where the time frame and the dollar amount needed to complete this project kept growing. And ultimately, at the point we completed the audit, the estimate at that point in time was $96 million for this project. Initially, it was estimated to be $28 million for 37 entities. The $96 million will provide Breeze for ultimately 18 entities, 10 that implemented in October of 2013, an additional 8 that hope to implement by March of 2016, and then the additional 19, it's our understanding, have been removed from the project at this point in time. So those are not necessarily included in that $96 million. So the costs have certainly escalated. So in our view, in our experts' view, the volume and the significance of all of these defects should have raised and prompted not only Caltech but DCA to essentially take a timeout and let's figure out where we're at, what we need to do to get Accenture to perform, to get some of these issues resolved. So we felt that the oversight certainly could have been stronger during the course of this project. I mentioned a little bit in my comments, project delays. One of the issues tied to the system requirements is you ultimately have what's called user acceptance testing, where the entities, these boards and bureaus, are testing the system to see if it's working, to see if it's doing what they expected it to do. The plan was to have user acceptance testing to take 8 weeks. It ultimately took 11 months. And what was occurring during that 11-month window was essentially changes to those system requirements. The boards and bureaus were using the system, testing the system, and saying, well, it's not doing X, and we were expecting it to do that, so we need to add that to this particular system. So there were a lot of changes that were occurring during user acceptance testing. And again, it ties back to the planning and those baseline requirements and really not having all of that done well up front. So the user acceptance testing, as we say in the report, basically morphed into a redesign and rework of the system. Escalating costs I spoke about, the initial estimate, as I said, was $28 million. The most recent estimate is around $96 million. I think in the staff report it's 95.4, something like that. But again, that only represents 18 of the original 37 entities that were planned to be part of Breeze. As far as the other 19 entities, many of those are boards and bureaus that have very complex systems. They have a lot of different licensing types. So phase 3, those 19 entities, or what was intended to be phase 3, seems to be a system that will be much more complex than the system that DCA is currently trying to implement they've rolled out at the 10 and intend to roll out at the 8 in 2016. So it's really unknown when and whether those 19 will be able to roll into Breeze and what the cost of that will be. The last issue is related to the contract terms. I had my attorneys look at the contract that the state entered into with Accenture, and we agreed to, DGS was involved initially early on. They had that responsibility. It is now under Caltech's purview, but at the time it was DGS, and DGS agreed to modify some of the state provisions that are actually in state boilerplate that would protect the state of California. Many of those were amended, essentially taken out as far as boilerplate. We agreed to too many things. The state took on too much risk, in our view, in revising some standard boilerplate terms in the contract. The other issue that we had, and still is in the audit report, but we'll be revising the audit report based on some testimony that occurred in front of Senate Sub 4, Senator Roth's committee. We originally we have a finding in the audit report that says the 3 contracts, you have a design contract, a maintenance contract, and a system license contract. As we describe in the audit report, all 3 of those contracts were essentially linked together. So if you canceled the design contract, you lost the maintenance contract and you lost the system license. And during the course of the audit, we had discussions with the department, with Caltech, and we concluded in the audit report, if those 3 are, unless those contracts can be amended to split them out, if the state cancels the design, we lose the other 2. At the March 12th hearing, there was testimony from the department that they had amended the maintenance contract in November of 2014 to basically, deconnect it from the other 2 contracts, particularly from the design contract. So we don't have that issue with maintenance, with the maintenance contract anymore. The concern, I have 2 concerns with respect to that. First of all, my staff were never informed that that amendment had occurred. And we had multiple meetings with both the Department of Consumer Affairs and Caltech. The agencies get to see a written copy of the report. We met with representatives from Caltech and DCA this past Friday. I mean, this was kind of late breaking. It occurred at the March 12th hearing. We reached out immediately. I asked my staff to make sure that we hadn't missed it, that we had perhaps received an email with this amendment and maybe we missed it. I'm confident that that did not happen. We've gone through all of our emails. We've gone through all of our work papers, reached out. We now have the amendment. I have asked my legal counsel to review the amendment, and we've identified some concerns with the amendment. Certainly, it's a good decision that the state of California basically separated the maintenance contract from design, so if we canceled design, we wouldn't lose maintenance. But there were some concessions that the state of California agreed to as part of that maintenance contract. I can go over those at a high level. We've done a high-level review of that, and I can certainly have counsel come up if necessary. But essentially what we've determined by looking at the amendment is it absolutely removes the provision that if terminated the maintenance contract if the design development contract was terminated. So that's a good thing. It also, however, added a provision that prohibits the state from terminating the maintenance contract for 6 months beginning January of 2015. Standard boilerplate in state contracts is to terminate for convenience is a 60-day window. So we've given Accenture 6 months. The effect of this is potentially paying Accenture $2 million during that 6-month window. In addition, the maintenance contract added $5.7 million to the ceiling. The ceiling was $3.5 million. Now the ceiling is $9.2 million. It changed some of the terms as far as the end date of the contract. It allowed for a couple of extensions. One issue that is a concern to us is the payment provisions in the previous contract was basically paying Accenture an hourly rate for any maintenance that their staff were performing on behalf of the state of California. The way the provision reads now is we essentially pay whether or not they're working on, it's a fixed rate. So we're paying whether or not they're performing maintenance services or not. And then a couple of other provisions, and again, my staff did a very quick review once we received the contract, and we actually got the contracts, my understanding from staff. We reached out to both Caltech and DCA and got it right away from Caltech. It removed the state's right to determine the acceptability of contractor personnel. Typically in a contract, we have the ability as a state to look at who a vendor is putting or providing to the state to provide services, and we can say, no, that we don't think that person has enough expertise. We think that it needs to be someone with more experience. We've removed that right to determine the acceptability of contractor personnel. And then the last issue, and again, this is one I think that may require additional analysis, but it expanded the scope of maintenance support services to include additional tasks. It includes new system report development, updates to existing reports, new interface development, et cetera. Our concern here is this really maintenance, or is this additional design work or additional work that's being done to essentially correct the issues that exist with the initial 10 entities that have rolled out Breeze in October 2013. So is this really maintenance, or is this fixing defects that currently exist in the system that's been rolled out? So I wanted to make sure I brought that to the committee's attention. We have had conversations with the department. We met with, my staff met with Awet and his staff last Friday, so we could have a discussion about this. I could raise my concerns from the perspective of, you know, full access to records and providing information to my office. We've gone through our audit report to figure out the effect on the audit report. What I am contemplating doing is just footnoting that couple of paragraphs in our audit report to reflect the fact that based on information that was brought to our attention subsequent to publication, that will revise that one conclusion that we have in the audit report. With that, that's the findings. We have a myriad of recommendations related to the issues, clearly related to planning. You've got to assess your business needs. We really have a strong recommendation with respect to the 19, do a cost-benefit analysis of what it's going to take, whether you want to use Breeze or some other system. Make sure you understand the business needs of those 19 entities. Training needs to be improved for not only the 19, but the 18 that eventually will all be using Breeze. Making sure that you're fixing issues that the IV&V consultants and the IPO consultants or staff from Caltech are identifying. You've got to address those issues and address them in a timely manner. So we have a series of recommendations. I don't want to go into all of them in detail, but we will certainly be tracking the responses that we get from the agencies. The way our office works is we issue a report, and then 60 days, 6 months, and 1 year are the first 3 intervals for which an agency needs to reply to us and let us know what the status is of their implementation for the recommendations. We have recommendations both for DCA and for Caltech, and we do have a handful of legislative recommendations as well. So that process will continue throughout this next year.
Thank you, Ms. Howell. Colleagues, any questions? Yes. Mr. Jones.
Ms. Howell, I know we're going to get into Breeze, you know, in more detail here a little bit later on, but can you tell us, are we reinventing the wheel here in California, or are other states using a system that's already designed that we could have just, for lack of a better term, purchased out of the box?
Assemblymember Jones, I'm not sure whether or not there are systems that other states use that the state of California could have used. What I do know about Breeze is there were discussions early on whether or not we needed to design a system from the ground up or whether to try to use an off-the-shelf system, which is ultimately what the state decided to do. But there have been so many changes to this off-the-shelf system. In hindsight, it may have been better for the state to have designed a system from the ground up, but I'm not aware of any other state systems that might be applicable to California.
So just to clarify, when this project started, which was before I got here, it wasn't considered an off-the-shelf product at the very beginning?
Well, no, there's discussion in the audit report in the introduction where we talked about the decision to use an off-the-shelf system, and initially the estimates were, well, if we design something from the ground up, it's going to cost us about $80 million. And this will be much more cost effective. It would be, at that time, the estimate was $28 million. So I think the decision was we could save the state a lot of money by using this off the shelf and make some modifications to it based on what the entities need, rather than spend $80 million to design something from the ground up.
Thank you.
Thank you. Ms. Baker?
Thank you. Regarding the changes to the contracts that took out some terms that generally are more protective of the state, I'm referring to the original contracts. I understand what you reviewed on Friday may also have done the same thing. were you able to get to why that was? What possible justification there was for taking those terms that are protective of the state out of the contract?
Well, I can have my staff counsel come up, but it's my understanding from staff counsel, it's unusual for those types of terms to be removed from a state contract. That's standard boilerplate that, in an attorney's view, really do protect the state. So I would have to defer to the department to give some rationale. But my staff counsel, Joe Porcher, can explain a little bit about his analysis and his conversations with the department.